Your house is yours until it isn't. And the moment you try to move it into a trust with a mortgage still attached, everything gets complicated fast. We're not talking about a minor paperwork headache here. We're talking about a legal tripwire called the due on sale clause that could force your entire loan balance due immediately if you make the wrong move. Think of the due on sale clause like a sleeping guard dog in your mortgage contract. It looks harmless until you try to hand the leash to someone else, and then suddenly everyone in the neighborhood knows about it. Most lenders bake this clause into your mortgage specifically to protect themselves, giving them the legal right to demand full repayment the moment that property changes hands to a third party without their blessing. Now here's where the plot twist arrives. Because the federal government actually looked at this situation decades ago and said, wait, that's not entirely fair. And in 1982, Congress passed the Garn-St Germain Depository Institutions Act. This law is essentially your legal shield, protecting you specifically when you transfer property into a revocable living trust where you remain the beneficial owner and still occupy the home as your primary residence. The irony here is almost poetic. The same government that lets banks write these aggressive clauses also quietly tucked in a carve-out that millions of homeowners have no idea exists. Even certain irrevocable trusts, like a qualified personal residence trust, or QPRT if you want to sound like you belong in the room, can qualify under the right structure as long as you still meet that beneficial ownership test. Now, if your property has zero debt on it, congratulations, you are living in the promised land. It's a clean deed transaction. No lender phone calls, no permission slips, just a straightforward transfer. But don't let that simplicity fool you into skipping the strategy conversation, because getting the purpose of your trust wrong can unravel your entire estate plan faster than you can say probate court. Ask yourself honestly whether this transfer is about asset protection, estate planning, generational legacy, or some combination of all three. Because each goal demands a different structural approach and a different level of legal precision. The misconception we see constantly is people assuming that trust equals protection in every scenario automatically, when in reality, a poorly structured or incorrectly titled trust can leave your heirs fighting the exact battle you were trying to prevent. History shows us that the people who navigate these transitions successfully aren't necessarily the wealthiest or the most legally sophisticated. They're the ones who slowed down, asked the right questions, and respected the process before signing anything. Discipline here doesn't mean being paralyzed by fear. It means understanding your objective clearly, working with the right professionals, and not letting urgency push you into a shortcut that costs your family far more than it saves. The rules exist, the protections exist, and the pathways are real, but only for those willing to play the game correctly. And if you're ready to take that first step in real estate investing, need a trusted contractor, or want to connect with a lender who understands these structures, check out our links in the description below.